Hello and welcome. Today, we're going to explore a very important part of the legal system, Rule 65 of the Rules of Court. This rule covers three special legal remedies: certiorari, prohibition, and mandamus. By the end of this video, you'll be able to define each of these remedies, understand when and how to use them, and identify common issues that arise. Think of these as emergency tools in a lawyer's kit. They are not for every case, but for specific situations where a court or government body has gone seriously wrong. We'll break down each section of the rule, provide real-world scenarios, discuss potential problems and their remedies, and even share some helpful tips and acrostics to make it easier to remember. Let's start with the first remedy, certiorari. This is covered in Section 1 of Rule 65. Certiorari is a legal action you can take when a court, board, or officer has made a decision without or in excess of its jurisdiction, or with grave abuse of discretion. In simpler terms, it's for when a judge or official has acted outside their legal authority or has made a decision that is so unreasonable it's considered an abuse of power. A key requirement is that there must be no other plain, speedy, and adequate remedy available. This means you can't just file a certiorari petition because you lost the case. You must have exhausted all other options, like filing an appeal or a motion for reconsideration. This is a crucial point. Certiorari is a last resort, not a first choice. Let's look at a sample scenario. Imagine a judge issues a warrant for your arrest in a case where the law clearly states that no warrant is required. This is an act without jurisdiction. You could file a petition for certiorari to have that warrant annulled. Here's a common problem. A petitioner files for certiorari without first filing a motion for reconsideration. The remedy for this is to file that motion first. The court will likely dismiss your petition if you haven't. A good tip to remember is the acronym JAD. D. J for jurisdiction, A for abuse of discretion, and D for no other adequate remedy. If you have JAD, you might have a case for certiorari. So to recap, certiorari is a special remedy for correcting serious errors of jurisdiction or grave abuse of discretion by a court or official, but only when no other ordinary legal remedy is available. Next up is prohibition, found in Section 2. Prohibition is similar to certiorari, but with a key difference. While certiorari is used to annul a proceeding that has already happened, prohibition is used to stop a proceeding that is about to happen or is currently ongoing. It's a preventative measure. You're asking the court to command the respondent to desist from further proceedings. The grounds are the same as certiorari, lack or excess of jurisdiction, or grave abuse of discretion. The requirement of no other plain, speedy, and adequate remedy also applies. However, prohibition can be filed against a wider range of respondents. It's not just for judicial or quasi-judicial bodies, but also for those exercising ministerial functions, like a government agency issuing a permit. Let's consider a scenario. A city council is about to pass an ordinance that is clearly unconstitutional. A citizen could file a petition for prohibition to stop the council from enacting the ordinance. This is a classic case of preventing an act that would be in excess of jurisdiction. A common issue is confusing prohibition with certiorari. Remember this simple acrostic: S stop, the for, S for stop, T for tribunal, O for ongoing, P for prohibition. If you want to stop an ongoing proceeding, think prohibition. So prohibition is your remedy when you need to prevent an unlawful act or proceeding from taking place or continuing. It's about stopping something before it causes more harm. Our third and final special remedy is mandamus, covered in Section 3. Mandamus is different from certiorari and prohibition. It's not about stopping an unlawful act, but about compelling a lawful one. You file for mandamus when a tribunal, corporation, board, officer, or person unlawfully neglects to perform an act that the law specifically requires them to do. In other words, it's for when a public official or body is failing to do their job, and that failure is harming your rights. Again, the requirement of no other plain, speedy, and adequate remedy applies. You can't use mandamus if there's a simpler way to get the official to act. A key point here is that the duty must be ministerial, not chaos, discretionary, fias slant. A ministerial duty is a clear, specific task that the law requires. A discretionary duty involves judgment and choice. Let's look at a scenario. You've applied for a business permit, and you've met all the requirements. The city official, however, refuses to issue the permit without any valid reason. This is a neglect of a ministerial duty. You could file for mandamus to compel the official to issue the permit. A common problem is filing for mandamus to compel a discretionary act. For example, you can't use mandamus to force a judge to rule in your favor because that's a discretionary act. The remedy is to appeal the decision if you lose. A helpful acrostic is DO, D for duty, O for omission. If there's a clear duty that has been omitted, think mandamus. So, mandamus is your tool to compel a public official or body to perform a specific, legally required duty that they are neglecting. Now that we understand the three remedies, let's talk about the practicalities of filing them. Section 4 covers when and where to file. This section is all about the deadlines and the correct court to approach. First, the deadline. A petition for certiorari or prohibition must be filed not later than 60 days from notice of the judgment, order, or resolution. This is a strict deadline. If you miss it, your petition will be dismissed. However, there's a crucial exception. If you file a motion for reconsideration or new trial, the 60-day period starts counting from the notice of the denial of that motion. For mandamus, the rule doesn't specify a deadline, but the Supreme Court has ruled that it must be filed within a reasonable time, usually within 1 year. A common problem is miscalculating the 60-day period. The remedy is to be meticulous with your dates. Always file a motion for reconsideration first to extend your time. Next, where to file. This depends on who the respondent is. If it's a municipal trial court, you file with the regional trial court. If it's a quasi-judicial agency, you file with the Court of Appeals. The Supreme Court has concurrent jurisdiction with the Court of Appeals and the regional trial court in certain cases. A common issue is filing in the wrong court. The remedy is to carefully check the rules on jurisdiction. For example, if you're challenging a decision from the National Labor Relations Commission, you must file with the Court of Appeals, not the Supreme Court. So, remember, timing and venue are everything. File on time and in the right court to give your petition a chance. Let's move on to Section 5, which deals with who should be named as respondents in your petition. This section clarifies the roles of the public and private respondents. When you file a petition, you must join two types of respondents. First, the public respondent, which is the judge, court, or agency whose act you are challenging. Second, you must join the private respondent, who is the person or persons interested in sustaining the proceedings in the court. This is usually the party who won the case you are challenging. The rule states that the private respondents have a duty to appear and defend the case, both on their own behalf and on behalf of the public respondent. This is a very important point. The judge or court you are challenging is typically just a nominal party. The real fight is between you and the private respondent. A common problem is failing to include the private respondent. The remedy is to amend your petition to include them. If you don't, your petition will be dismissed for lack of an indispensable party. Another key provision is about costs. If you win, the costs awarded in the proceedings are against the private respondents only, not the judge or court. This protects judges from being personally liable for their official acts. So always remember to name both the public and private respondents. The private respondent is the one who will bear the burden of defending the case. Let's now look at the process after you've filed your petition. Section 6 covers the order to comment. This is the court's first step in evaluating your petition. If the court finds that your petition is sufficient in form and substance, it will issue an order requiring the respondent or respondents to comment on the petition within 10 days. This means the court has done a preliminary check and believes your petition has merit. The comment is the respondent's opportunity to explain their side of the story. A common problem is that the respondent files a motion to dismiss instead of a comment. The remedy is to object to this. The rule specifically states that in petitions before the Supreme Court and the Court of Appeals, the respondents are required to file a comment, not a motion to dismiss. This is to expedite the proceedings. The court wants to hear the merits of the case, not get bogged down in procedural motions. Section 7 talks about expediting proceedings, injunctive relief. This section allows the court to act quickly and to issue temporary orders. The court can issue a temporary restraining order, or TRO, or a writ of preliminary injunction. This is a powerful tool that can stop the public respondent from proceeding with the principal case while your petition is being heard. A common issue is that the public respondent continues with the case even after a petition for certiorari is filed. The remedy is to apply for a TRO or injunction. Without one, the filing of the petition does not automatically stop the original case. So remember, the court will first ask for a comment, and you can ask for a TRO or injunction to protect your rights while the case is ongoing. Let's conclude by looking at the final stages of the process. Section 8 covers proceedings after comment is filed. This is where the court makes its decision. After the comment is filed, the court may hear the case, require the parties to submit memoranda, or simply decide the case based on the pleadings. If the court finds that the allegations in your petition are true, it will render judgment for the relief you are entitled to. For certiorari, this means annulling or modifying the proceedings. For prohibition, it means commanding the respondent to desist. For mandamus, it means commanding the respondent to perform the act. However, the court may dismiss the petition if it finds it is patently without merit, prosecuted manifestly for delay, or raises unsubstantial questions. A common problem is filing a frivolous petition. The remedy is to only file when you have a strong, legitimate case. The rule allows the court to award treble costs against the petitioner and counsel, and even impose administrative sanctions on the lawyer for patently dilatory petitions. Finally, Section 9 deals with service and enforcement of order or judgment. This is about making sure the court's decision is followed. A certified copy of the judgment is served on the concerned parties. Disobedience to the court's order is punished as contempt. This means if the court orders a judge to annul a proceeding and they refuse, they can be held in contempt of court. If damages or costs were awarded, an execution may be issued to collect them. So, the court has the power to enforce its decisions and ensure that justice is served. Let's quickly recap what we've learned today. We've covered Rule 65, which provides 3 special remedies. First, certiorari, used to annul a proceeding that has already happened due to lack of jurisdiction or grave abuse of discretion. Remember the acrostic JAD, jurisdiction, abuse of discretion, no other adequate remedy. Second, prohibition, used to stop an ongoing or impending proceeding due to the same grounds. Remember the acrostic STOP, tribunal, ongoing, prohibition. Third, mandamus, used to compel a public official to perform a specific ministerial duty they are neglecting. Remember the acrostic DO, duty, omission. We also discussed the strict 60-day deadline for certiorari and prohibition, the importance of filing a motion for reconsideration first, and the need to name both public and private respondents. Finally, we saw how the court processes these petitions, from the order to comment to the potential for injunctive relief and the enforcement of the final judgment. These remedies are powerful tools, but they are special and should be used carefully and correctly. Thank you for watching.